डिसीजन जितना जल्दी मिल सके वो हमारे देश के लिए अच्छा होगा और उस इंसान के लिए भी अच्छा होगा जो कि इसमें विक्टिम हुआ हो, वो दोषी है या नहीं है। बेकार में 10-10 साल 8-8 साल जेल में लोग रहते हैं, 10 साल के बाद पता चलता है वो निर्दोष है। तो इस चीज को हमको देखना बहुत जरूरी है। मैं आपके माध्यम से माननीय मंत्री महोदय को अनुरोध करता हूं कि इस चीज को आप रेक्टिफाई कीजिए, ताकि जो सरल लोग हैं, कोई बेकार बेमतलब का फंस के रहते हैं, जेल में अपना जिंदगी काटते हैं, उन लोग जेल से कैसा मुक्ति पाएंगे, इसको आप जरूर देखिए। बहुत बहुत धन्यवाद, नमस्कार।
धन्यवाद माननीय मुजीबुल्लाह खान जी। माननीय श्री बीडा मस्तान राव यादव जी, प्लीज।
Thank you, sir. Thank you for giving me opportunity to speak on such an important bill on behalf of our YSRCP party. We have no objection to this bill and welcome it wholeheartedly. It is a credit to this government that they have brought in such a widespread changes and sought to alter laws and regulations that have become absolute. India is a dynamic nation, and our constitution makers were aware of this when they laid down the fundamental principles which would guide our nation, but allowed for enough flexibility to make changes and ensure that no law could keep the people of India entrenched in the past. The fact that this government has made concerted efforts to unearth contradictory and absolute legislation, some of which dates back to colonial times, ensures that we honor our roots as a nation open to change and progress. Additionally, it severs any unnecessary ties to outdated draconian laws from the era of British rule and usher our country into a new era of liberation where we actualize our dreams of becoming Vishnu Guru. Our suggestions, sir, AP Recognition Act. While I wholeheartedly support the breadth of the changes being made through this bill, I would also like to highlight that Andhra Pradesh had requested an amendment to the Andhra Pradesh Reorganization Act 2014. This has been brought to the attention of this House through multiple interventions, including private members' bill and through the government more directly through personal representation from honourable MPs and state leaders of Andhra Pradesh. We have requested that promises made under AP reorganization be actualized in a time-bound manner. There are several matters which till date have no end in sight. This includes the Central Tribal University promised to Andhra Pradesh government, which only began functioning in 2019 from a temporary campus. There is no clarity on when a permanent campus will be provided.
Please speak on the subject.
Sir?
You speak on the subject, Mastan Raoji.
No, this is also some amendment to a reorganization bill is required, sir. This is our humble request.
It's good.
Similarly, we request that special category status be provided to the state. Such a status would enable us to get a higher share in central grants and tax incentives, resulting in the reduction of financial burden on the AP government. It is required by AP because we have been fiscally struggling due to an unscientific bifurcation, wherein amongst numerous resources we lost our capital city also. Even the 15th Finance Commission has stated that given such a status is within the mandate of the centre to provide if it deems it necessary. I request that in face of new changes being brought by the government, this too be given due weightage. Additionally, the funds promised to AP for development projects should be handed over to our government in a smooth and efficient manner. Till date, many projects such as the Polvaram irrigation project are stuck halfway due to disputes over funding. This disrupts the intent and nature of the law, which was meant to provide developmental support to Telugu people. I request that these stipulations be reconsidered and the commitments made to us be legally
strengthened. You know the rules.
Yes, sir.
You know the rules. You have to speak on this bill. You have to speak on this bill as per rules.
There are a few laws which too need amendment because they are simply baffling and highly outdated considering our times. I would like to highlight the following. As per the Indian Aircraft Act 1934, any Indian citizen who flies balloons or kites without license is an offender. The House is well aware that flying kites is a common method of celebration and strong part of Indian cultural ethos, especially for children. While this is not usually implemented, it is the time the stipulation be removed. The Indian Treasure Trove Act of 1878 states that any treasure found under the soil which is equal to or more than 10 rupees has to be reported and shared with the government. If any person does not do so, they are liable to be arrested. This is vague and extremely confusing for the general public, and this can easily be misused by mischief makers to prosecute innocent citizens. On a more grave note, there are pressing laws that need urgent reform so as to prevent serious miscarriages of justice. This includes the Indian Penal Code and severe laws pertaining to the treatment of criminals. For example, as per Section 294 of the Indian
Please, your time is over. Your time is over.
As per Section 294 of the Indian Penal Code, any
Mani Bida Mastan Rao ji, your time is over.
Conclusion, sir. I have already stated that I wholeheartedly, on behalf of our YSRC party, support the proposed bill.
Thank you.
My speech, I merely wish to point out certain inconsistencies which cannot be allowed to remain.
Thank you. Conclude. I am calling Mani Shri K.R. Suresh Reddy ji.
Okay, sir.
Mani Shri K.R. Suresh Reddy ji. The mic is on now.
Yeah. Thank you, sir, for giving me this opportunity to speak on this, though considered a normal, a routine bill, but with a lot of significance. The Honourable Minister, in his explanation of the bill, has very rightly stated that some of the bills which are outdated, antiquated, which have lost their relevance, need to be withdrawn, repealed. Well, that definitely is a good measure. It's a measure which can lessen the burden on the judiciary. It's a measure which can sharpen the bureaucracy and ultimately help the people at large. So, any initiative in this regard, general help to the people is always welcome, and getting updated is a very good initiative, especially today and more so in the international forums. Having said that, having appreciated their initiative, you have to see the other side of the coin too, sir. When a bill is passed, the bill gets effective only after the rules are made. Now, when we see the bills, there are so many bills which have been passed where the rules are being pending, and the subordinate legislation goes through all this. And just the other day, we had a presentation of so many reports stating very clearly that the bill passed, the rules not being framed, and they have been delayed for a considerable period of time. Now, the onus lies on the Honourable Parliamentary Affairs Minister to look in this direction. While the government is reforming, the legislature, the Parliament also needs to rise to the occasion. While the government is reforming, the Parliament has even more bounded duty to realize its realism, because ultimately the laws are made here. So subordinate legislation is one area which needs your attention. Another most important aspect of any legislation, Deputy Chairman, sir, is how do you analyze the impact of it, the legislative impact assessment. There are two ways of looking at it. One is before the bill is introduced by the government definitely puts it up in public domain for its input. There's only a policy in 2004 which has been framed, but there's no law which mandates the government that any bill proposed should be put in public domain. And to quote a small example, from 2016 to 2019, Deputy Chairman, sir, there were almost 186 bills introduced, out of which 142 bills did not get public scrutiny before coming here. So that is very glaring. In such a big democracy where the public input is not taken before the introduction of the bill, creates a lot of, I would say, more than uneasiness to the people, also trouble to the government. And then comes the post, after the bill is introduced and passed, how effective is the bill? Is there any impact assessment mechanism? Well, world over, most of the developed countries do have this mechanism. They evaluate how beneficial the bill is to the people. If there are certain amendments to be made, it will come through that, and then the government can come in through those necessary changes. One good example for that impact assessment not being done and the damage being done to the society at large and to the government in particular was the farm bills. The farm bills were introduced. The impact assessment was not done. We went through a huge dharna, people died, and ultimately the government had to go back on that. So this is one area where the legislature, and more so from your side, sir, from the chair side, we need to get a little more dynamic in this and ensure that the Parliament lives up to its bestowed responsibilities. And finally, sir, last thing is the international treaties. There are so many international treaties the government is signing. While you have removed a lot of outdated bills, there are certain treaties which come in. For example, the Antarctic Bill came in. A treaty signed 40 years ago, now you come and made that into a bill. So the government should realize all these international treaties which you are signing, you are coming to this house after 20 years, 30 years, where the relevance is lost. So while welcoming, removing the outdated bills, I also seek the Honourable Minister's intervention in this regard and ensure that we not only become, finally, just a small thing. That
your time is already over. 1 minute more.
Well, if my time is over, I respect your thing, sir. I thank you for it.
Please. No, you want to speak, conclude, you please do.
So, I was just talking about, we being a representative democracy, and if the suggestions suggested by most of us from here, if I read it, then you turn into a responsible democracy. That is what the country needs today. Dynamism doesn't mean just removing outdated bills, but dynamism means that you bring in legislation which is beneficial to the people, and also before legislation and after legislation, involve the people. So that is how the bills in letter and spirit would be appreciated. Thank you,
Thank
sir.
you. Thank you, Mani K.R. Suresh Reddy ji. Mani Shri A. Rahim, not present. Dr. M. Thambi Durai ji.
Thank you, Deputy Chairman, sir. On behalf of ADMK Party, I am participating. Honourable Minister has brought the bill, the Repealing and Amendment Bill 2020. Since 1950, sir, there have been various repealing and amending acts. Acts of 1,300 acts were repealed from 1950 to 2001. There have been 2 repealing and amending acts in 2015 and 2017, each and one in 2016. The latest act is the Repealing and Amending Act 2019. The act is a periodic measure taken by the legislature to repeal laws which are obsolete and defective. Sir, there is some kind of things we know that most of the acts are enacted the British period, the Parliament that, even though we are calling our Indian Constitution, still had whatever the British acted laws are still prevailing. Therefore it is a part of that. There is one thing is that there are simple of old, there may be old laws. Other countries also have old laws. But why the repealing means the old laws not necessary. These old laws can be used to harass the people. Therefore, what is the necessity of this kind of acts? That is the rules. And also, sir, I want to bring to the Honourable Minister. Honourable Minister.
Yes, Dr. Thambi Durai ji, please.
Honourable Minister, I want to bring to his knowledge, because I want to say it's a very important issue. Sir, around 65 of cases are pending in Supreme Court. 4 million in high courts and 26 million in lower courts. So many cases are still pending. That is 40 million pending. Therefore, this kind of laws, when we are having so many laws, it is very difficult to overcome the problems of the claims. As our honourable member said very exactly, the laws are meant for the public, for democracy. For democratic spirit, we are bringing legislating laws. It must be useful for the people. If at all not useful, there is no use for it. Therefore, in that sense, if honourable minister has brought this kind of amendment, these are old laws to repeal, they are appreciating that. I hope that the new laws, when we are old laws also, when we are removing that, if at all any relevancy is there in that laws also, that has to be modified and kept for this, for the public. We cannot simply remove all the laws because the British brought. That is my suggestion.
Thank you, Dr. M. Thambidure ji. माननीय श्री महेश जेठमलानी जी. माननीय श्री महेश जेठमलानी जी, 3 minutes.
Sir, this bill is a formal bill. It's basically a case of legal house cleaning, sir. Our legal go-down had become overfull with laws which are obsolete, some of which were pointed out by the previous speakers and the law minister in particular. So, sir, there was a need for some legal house cleaning, particularly, sir, since the previous government had not undertaken this task and left many obsolete laws. So the work of this government ever since 2014 has been in that direction. And of course, it's unlike empty slogans like Garibi Hatao, it's towards the policy of Nyuntam Sarkar, Adhiktam Shasan. So it's an exercise in that direction. And it's an exercise essentially in, as I said, cleaning our legal go-downs. Now, so there are 3 categories. As I said, it's a very short bill, but there are 3 categories. And from those categories, which are set out in 3 different schedules, one will be able to discern what are the natures of the laws that are being got rid of now. So, sir, in Schedule 1, they are laws which are basically either obsolete, they are being repealed altogether. As the Honourable Law Minister pointed out, for instance, a law which has been overtaken by technological advancement. So the Telegraph Wires Unlawful Possession Act, this is now almost obsolete. Nobody uses it anymore. We are in the age of spectrum now. So, sir, this law is obsolete. And many of them are colonial laws. They date from 1850, 1855, and so on. So they have been removed from the statute book. So then there are laws which are amendment laws. If you see, half of the first schedule are what are called amendment laws. Now, those are amendments to existing statutes. These are amending acts, and these amendments have now been incorporated into the parent act. So they have become completely useless now. They are of no purpose being on the statute books. They only serve overburden our legal go-downs and our statute books. So the second schedule, if you see, is almost entirely of appropriation bills for a particular year. So you have an appropriation bill for 2013, 14, 15, 16. Now these have time limits. They're only for that year. They have outlived their time purpose now. Their shelf life is over. So these also have to be, they're unnecessarily still on the statute books, and they have to go. So this is the second category. And the last category is a single case, sir. If it was a case of an amendment, then, sir, it would be, or a serious amendment to any act, then, sir, it would be discussed, it would be debated in both houses. But this is a formal amendment. One word has been dropped in a particular statute, which is the Factoring Regulation Act. So there is an amendment act of very minor consequence. It's more a grammatical change. And so that is why the third schedule is there, which consists of an amendment to only one act, which, as I said, is the Factoring Regulation Act. So, sir, as I said, the policy of minimum government, maximum governance, this is an act to further that object. It is an act to further the absence of harassment to ordinary citizens, particularly the poor, and to enhance the ease of living and ease of doing business for businessmen and such categories. Sir, I wholeheartedly welcome this bill. It's a necessary bill. Formal though it is, at least, sir, it's an exercise in much-needed legal housekeeping. I thank you for giving me permission to speak, the Law Minister and my parties. Thank you, sir.
धन्यवाद माननीय महेश जेठमलानी जी। माननीय श्री राघव चड्ढा जी, माननीय श्री राघव चड्ढा नॉट प्रेजेंट। माननीय डॉक्टर फौजिया खान, माननीय डॉक्टर फौजिया खान नॉट प्रेजेंट। माननीय श्री नरेश बंसल जी, माननीय श्री 3 मिनट।
तुम्हारे हाथ की
माइक इज ऑन।
धन्यवाद उपसभापति जी। मैं अपने नेतृत्व का धन्यवाद करता हूं जिन्होंने मुझे इस विषय पर बोलने का आदेश दिया है। हमारे यशस्वी प्रधानमंत्री नरेंद्र मोदी जी के नेतृत्व में जब से देश में सरकार आई है, न्यूनतम सरकार अधिकतम शासन, और इसको लेकर जो आजादी के पहले से गुलामी की मानसिकता की चीजें थी उनको हटाने का अभियान चला। समाज में सब प्रकार से स्वच्छता अभियान चलाने का काम प्रधानमंत्री जी के नेतृत्व में हुआ और हर क्षेत्र में उसका परिणाम भी देखने को मिला। वह केवल झाड़ू वाली स्वच्छता ही नहीं, अनेक प्रकार से आज का जो विषय है रीअपीलिंग ऑफ अमेंडमेंट ऑफ एक्ट, जिसमें बहुत सारे कानूनों को जो एक प्रकार से भार थे हमारी जनता के ऊपर, उनको समाप्त करने का काम सरकार प्रारंभ से ही कर रही है। ऐसे अनेक कानून, क्योंकि मान्यवर मैं आपके माध्यम से कहना चाहता हूं कि अंग्रेजों ने जो कानून बनाए थे वो इसलिए बनाए थे कि वो हम पर शासन कर सकें, हमको प्रताड़ित कर सके। वो कोई सुधार के लिए नहीं थे, अपने शासन को मजबूत करने के लिए थे। आजादी के बाद वो कानून समाप्त होने चाहिए थे, जिस पर किसी ने ध्यान नहीं दिया। लेकिन हमारे प्रधानमंत्री जी ने हर क्षेत्र में जो पुराने पुराने बर्डन थे उनको समाप्त करने का काम किया। 40 साल की 1 रैंक 1 पेंशन, उसको सॉल्व किया। इसी प्रकार से हमारी शिक्षा नीति 34 साल के बाद उसमें परिवर्तन किया, जिससे आने वाली पीढ़ी देश के स्वाभिमान की आवश्यकता के अनुसार देश के शासन में सहयोग कर सके। इसी प्रकार से कानून के अंदर भी ऐसी बहुत से कानून, लगभग 1486 कानून, ये इनको निरस्त किया गया। जो एक कमीशन बना 2 सदस्य, उसकी रिकमेंडेशन पर, क्योंकि ये एक भार थे हमारे ऊपर। बहुत सारे कानून लागू ही, उनका आवश्यकता ही नहीं थी, लेकिन वो कानून की किताबों में भी बोझ थे, हमारे जजों के ऊपर भी बोझ थे, हमारे वकीलों के ऊपर भी बोझ थे और हमारी जनता के ऊपर भी बोझ थे। उनको समाप्त करने का काम ये हमारी सरकार ने किया है। आज उसी प्रकार से हमारी सरकार ने जो 2014 में 2 सदस्यीय समिति का गठन किया गया था, उसके आधार पर 1458 अधिनियमों को और इसी प्रकार से निरसित कर दिया गया और संबंधित मंत्रालयों द्वारा निरसन के लिए जो 28 संशोधन अधिनियम छांटे गए, उनको भी निरस्त कर इस प्रकार 1486 अधिनियमों को निरसित किया गया। माननीय वरूप सभापति जी, मैं बताना चाहता हूं कि जिस प्रकार से ऊपर कहा गया कि अधिनियमों को निरसित करने के लिए अभ्यास का उद्देश्य नागरिकों के लिए अनुपालन के बोझ को कम करना, हर आम आदमी को सुविधा प्रदान करना, सभी क्षेत्र में जिस प्रकार इजी डूइंग बिजनेस में अनेक प्रकार के कानूनों को निरस्त करके हम जीएसटी लेकर के आए, जिसमें 17 कानूनों को पूरे 1 नेशन 1 टैक्स करके सम्मिलित किया गया और लोगों को व्यापार में और टैक्स देने में सुविधा प्रदान की गई। इसी प्रकार से हमने इजी लिविंग में भी बहुत सारे सुधार के काम किए हैं। उसी को आगे रखते हुए हम इस प्रकार से आज ये बिल लेकर के आए हैं। माननीय हमारे कानून मंत्री जी जो बिल लेकर आए हैं, मैं उसका समर्थन करने के लिए खड़ा हुआ हूं, क्योंकि यह बिल उन 229 राज्य अधिनियमों को
निरस्त करने के लिए जो राज्य को भेजा गया था, संबंधित राज्य सरकार ने अब तक 79 उसमें से निरस्त कर दिए गए हैं और आज ये 65 कानून जो अधिनियम को निरसित करने के लिए आज ये कानून पुनर्स्थापित किया गया है, इसमें 11 कानून और जोड़े गए हैं जो स्वतंत्रता से पूर्व के थे, जिनके कारण आम आदमी को बहुत असुविधा होती थी। आम आदमी के मतलब के वो कोई कानून थे नहीं, केवल कानून की किताबों में वो बोझ के रूप में पड़े हुए थे। आम आदमी को उससे परेशानी होती थी। हमारे जजेज भी उसके दबाव में रहते थे, हमारे वकील भी उसके दबाव में रहते थे और जनता को किसी प्रकार की उससे सुविधा नहीं थी। जनता के लिए भी वो एक प्रकार से हर्डल थे। लोकसभा में 27/7/2023 को इसके लिए 76 अधिनियमों के लिए जो बिल लाया गया था और वहां पर वो पास हुआ है, उसी को आज यहां पर लाया गया है। माननीय सभापति जी, हमारी सरकार न्यूनतम सरकार अधिकतम शासन, इसके लिए जानी जाती है। हर क्षेत्र में कम से कम सरकारी हस्तक्षेप हो और हर आदमी को सुविधाजनक रूप से देश के नागरिक के रूप में, कर्तव्यवान नागरिक के रूप में अपना दायित्व निर्वहन करने का मौका मिले। इसके लिए हमारी सरकार हर क्षेत्र में काम कर रही है। हमने इसी प्रकार से देखा कि जो देश के अंदर विदेशों से फंडिंग वाले, बैठ जाऊं सर?
नहीं, कंक्लूड करो, बैठो मत।
हमने देखा कि
यू आर मेकिंग वेरी गुड पॉइंट्स।
मैं कर रहा हूं सर,
तो उनको कंक्लूड करो।
हमने देखा कि विदेशों से फंडिंग वाले ऐसे अनेक एनजीओज थे जो देश को तोड़ने वाली ताकतों के साथ जुड़े रहते थे। ऐसे लगभग 20,000 एनजीओ निरस्त किए गए। 2 लाख के करीब शेल कंपनियां, जिनके माध्यम से मनी लॉन्ड्रिंग के काम होते थे, काले धन को सफेद करने का काम होता था, उनको निरस्त किया गया। इस प्रकार से हर क्षेत्र में सुधार करने का काम हमारे यशस्वी नेता नरेंद्र मोदी जी के कार्यकाल में हो रहा है। और अभी पिछले दिनों ही हमने देखा किस प्रकार से अंग्रेजों के बनाए हुए पुलिस एक्ट और क्रिमिनल प्रोसीजर कोड और एविडेंस एक्ट, उनको निरस्त करके अपने नागरिकों के स्वाभिमान के अनुसार नया कानून बनाने का काम हमारी सरकार ने किया है। इस प्रकार से सभी जो देश के ऊपर इस प्रकार के भार या अनुपयोगी कानून थे या जिस क्षेत्र में भी अनुपयोगिता है, उसको समाप्त करके हम देश को अगले 25 वर्षों में संकल्पबद्ध हैं कि हम भारत को विकसित राष्ट्र बनाएंगे और उसके लिए हम इस प्रकार के सारे सुधारात्मक कदम उठाने का काम कर रहे हैं। माननीय सभापति जी, आपने मुझे बोलने का मौका दिया, उसके लिए मैं बहुत बहुत आभारी हूं। धन्यवाद, नमस्कार।
श्री पी विल्सन, 5 minutes, sir.
Sir, this bill amends and introduces Section 3G to establish a tribal university in Telangana with the budgetary provisions of 889.07 crores for 7 years in 2 phases. Thank you, Chairman, sir. I will talk on this. Sir, so far as this repealing bills are concerned, sir, it is better to have a sunset clause in all the bills. Whenever you introduce a bill, you should have a sunset clause so that once the bill is introduced and act is passed, that sunset clause by itself, the bill becomes defunct and it amounts to a repeal. So this sunset clause has to be introduced so that we can avoid this much of valuable time in future for having a separate repeal bills. I understand whenever you bring in an amendment by way of an act, that amendment act will be there and it can be repealed only by a repeal act. So when you introduce this type of sunset clause in the bills, that will help us to save much time of this House and we can debate on the people's issue, number one. Sir, so far as number two is concerned, sir, whenever you bring an act, why don't you consult the stakeholders? I have seen, sir, I have been in the Committee of Law and Justice. Sir, the judiciary is taking the strain of hearing or because of the act which is being brought. So why don't you have a judicial impact assessment being done whenever a bill is introduced into the House? Before a bill is introduced into the House, why don't you have a consultation with the stakeholders, consultation with the judiciary, consultation with the advocates, consultation with the persons who is going to be affected by the bill? So, for example, I would say the Negotiable Instrument Act, when you brought an amendment, Section 138 of Negotiable Instrument Act, it had a docket explosion. All of a sudden, lakhs of cases overnight, the courts have to hear. So there was not much of infrastructure. And our Honorable Chairman, I would say with pride, he belongs to our community, namely from legal fraternity. The Chairman knows that if you introduce a bill and when it becomes an act, how far it is going to have an impact on the judiciary, on the litigants. So this study can be done before a bill is being introduced so that it will not be a surprise for all of them. If you want to bring an act which is going to affect a trade community or it is going to affect lawyers or other set of peoples, so why don't you have a hearing and tell them, and so you can also interact with them and they will also be suggestion. No, why I am saying is, there are a lot of amendments being brought. Sir, I will say today, take Arbitration Act, sir. Sir, under Section 34, if you want to set aside an award, the court which is hearing a matter against an award passed by an arbitrator, it has no power to modify a decree. It has to only set aside and send back again to the arbitrator. Sir, arbitrators are taking about years together. Imagine an arbitration goes on for about 5 years. And when the matter comes to the court and the court hears the matter, and after another 5 years, if the court is not empowered to modify award and make it as a decree, and the power is only to the extent of sending it back to the arbitrator, sir, these types of power, sir, has to be regulated by way of having a discussion with the stakeholders whenever before it is being introduced before the Parliament. So that is what, sir, I would say, that these repealing acts are unnecessary. You can stop it by introducing a sunset clause at the beginning itself. So that would be my suggestion, sir, so that we can avoid, the wastage of time of this House. And if this sunset clause, this has been followed in the foreign countries, I could say. So this can be adopted and we could save time. We can concentrate much on the people's issues and the other issues can be taken into consideration. Number one. Sir, another important issue, sir, which I have been telling you is, sir, the social diversity is not there in the judiciary, sir. When you take the representation of the number of judges in the High Court or the representation in the Supreme Court, sir, the social diversity is lacking in the High Court and it is also lacking in the Supreme Court, sir. Please see, sir, the information given to the Parliament by the Ministry of Law and Justice. If you see from 2018 to 2023, sir, I am told that about 80% are from the upper caste. I would say from the one community. I don't want to name the community. And the rest of 20%, sir, are coming from the backward class and from the scheduled caste and scheduled tribe. And if you see the Supreme Court, sir, is still worse. So we had, in fact, sir, we had even brought a report.
You have made your point, sir. Very, very emphatically, you have made your point.
Yes. So I would only ask I'm grateful to the chairman. And this representation, why don't you consider, sir? Sir, what is wrong with a backward class person coming as a judge? And do you think that he can't deliver judgment? Sir, I can see two things, sir. Whether the collegium has failed to identify a person with whose merit from other classes, or whether the collegium is not interested in identifying a meritorious persons from the other
You
classes.
have made your point, sir.
So therefore, high time, Chairman, sir, that let this be considered. And thank you very much for allowing me to speak on this bill.
Before I call upon the Honorable Minister to reply the discussion, lawmaking is a very serious business. We alone are entrusted with lawmaking. And there are two different categories. If Parliament, which is the ultimate architect of the Constitution, makes some change in the Constitution, that is final. There can be no intervention from any agency, be it executive or judiciary. But if there is a legislation, judiciary has a method of intervention by way of judicial review, because every legislation has to be in accordance with constitutional prescriptions. So things are very categorical. To the extent a constitutional provision is concerned, any intervention, Honorable Minister, any intervention with respect to constitutional provision emanating from Parliament is not acceptable. Parliament is the only reflector of the opinion of the people. This is by way of a structured platform. People of this country indicate their mindset through the ballot and send their representatives here. I'll just tell you, we must be quite serious about it. I'll just read one provision of the 10th schedule of Indian Constitution, and that will surprise all of you. And that is 10th schedule, clause 6. Decision on questions as to disqualification on ground of defection. But if you go to proviso, provided that where a question has arisen as to whether the chairman or the speaker of a house becomes subject to disqualification, the question shall be referred for decision of such member of the house as the house may elect in this behalf, and his decision shall be final. Now just reflect, where is the question of disqualification of chairman Rajya Sabha? So we have to be extremely careful. This was drafted at a time, it was just before we came to power in 1989. So it's a serious business. I will urge all of you that we are the ultimate custodians of the rights of the people, sovereignty of the people, by ensuring that we act diligently, vigilantly, with thorough preparation, make appropriate inputs, and do not permit any incursion whatsoever. What is our mandate? And that is ultimate authority to ensure constitutional compliance and be the architect of Constitution. Any intervention in this area should be repelled. There was an occasion where we discussed an important bill. I was looking right, left and center that someone would reflect, can the highest court of the land make an interim legal arrangement? That is 100% mandate of this House. I am sure we will engage more seriously when it comes to lawmaking. Honorable Minister, Sri Arjun Ram Meghwal, to reply the discussion. These reflections were because the Honorable Minister is handling the Department of Law and Justice.
Thank you, sir. ऑनरेबल चेयरमैन सर, ये जो द रिपीलिंग एंड अमेंडिंग बिल जिस पे आज ये महान सदन चर्चा कर रहा है, इस बिंदु पर या इस बिल पर 8 लोगों ने अपने विचार रखे। जीवीएल नरसिंह राव जी से लेकर के और पी विल्सन तक सबने विचार रखे। इसमें हमारे तंबी दुराई जी ने भी विचार रखे और महेश जेठमलानी जी भी, नरेश बंसल जी, के.आर. सुरेश रेड्डी जी, मस्ताना राव बीडा जी, मुजीबुल्लाह खान, सबने अपने विचार रखे, सबने अपने सुझाव भी दिए और सबने ये माना कि जो कानून जिनकी अब कोई उपयोगिता नहीं है उनको समाप्त कर देना चाहिए। सबने इनका बिल का समर्थन भी किया। सभापति जी, ये एक विषय है जो जनरल एक परसेप्शन भी है, एक सिद्धांत भी है, एक प्रिंसिपल भी है कि मनुष्य की प्राकृतिक मौत हो सकती है। मनुष्य उसकी एक्सीडेंट भी हो सकता है। जैसे एज आई 100 साल, 80 साल, 70 साल, तो एक प्राकृतिक मौत हो सकती है। लेकिन को अधिनियम है, उसकी प्राकृतिक मौत नहीं हो सकती। उसको अगर किल करना है तो संसद में ही लाना पड़ेगा। इसलिए हम आपको बार बार आकर के यहाँ किल करने का प्रयास क्योंकि आवश्यकता नहीं है ना ऐसे बिलों की, लेकिन बार बार आ रहे हैं। कई लोगों ने कहा एक साथ आ जाओ, बार बार बताओ। कुछ लोगों ने सनसेट क्लॉज जैसे सुझाव भी दिए, लेकिन मैं इनको बताना चाहता हूं कि ये प्रक्रिया ऐसी है, ये नेचुरल डेथ का विषय नहीं है, क्योंकि पार्लियामेंट से पास है, कुछ राज्यों की विधानसभाओं से पास है, वो संसद में आना ही पड़ेगा। देखिए, हर बिल में एक एक्ट का नंबर होता है सर, हर बिल में एक्ट का ईयर भी होता है, कौन सा लेजिस्लेचर लेके आया, किस विधानसभा ने पास किया है, पार्लियामेंट ने पास किया है, इसका उल्लेख भी होता है। और जिसका पुरुषोत्तम जी रूपाला साहब बार बार जिक्र करते हैं, वो इनेक्टिंग फॉर्मूला भी होता है। तो ये सारी, और रिपब्लिकन ईयर भी उसका होता है। तो ये सारी चीजें होने से हम सबको एक साथ लेके आ जाएं, ऐसा हो नहीं रहा है। लेकिन फिर भी इसमें हम प्रयास कर रहे हैं। सनसेट क्लॉज के बारे में आपने जिक्र किया, इस संबंध में हम प्रयास कर रहे हैं। जो बिल था ओरिजिनली, इसमें 65 ऐसे अधिनियम थे जिनकी कोई आवश्यकता नहीं थी। एक ऑफिशियल अमेंडमेंट के द्वारा ये 11 ऐड हुए हैं, तो टोटल 76 ऐसे कानून जिस बिल की हम चर्चा कर रहे हैं। अब तक मोदी जी के आने के बाद, मोदी जी 2014 में शासन में आए, मोदी जी के आने के बाद 1486 हम पहले ही ऐसे कानून जिनकी आवश्यकता नहीं थी उनको समाप्त कर चुके हैं। 76 ये जो आज महान सदन इसको पास करेगा, तो टोटल 1562 ऐसे कानून जो जिनकी आवश्यकता नहीं है वो समाप्त हो जाएंगे। तो जो नरेंद्र मोदी जी का एक प्रिंसिपल था, मिनिमम गवर्नमेंट मैक्सिमम गवर्नेंस, इस दिशा में हम तेजी से बढ़ रहे हैं और इससे नागरिकों के ईज ऑफ डूइंग बिजनेस और ईज ऑफ लिविंग का भी मार्ग जो है वो आगे बढ़ रहा है। कुछ ऐसे बिल थे जिनका जिक्र मैं अभी कर रहा था आपके आने से पहले, कि जैसे कुछ ऐसे बिल थे जिनकी कोई आवश्यकता नहीं है और नागरिकों को तंग करने के अलावा कोई काम नहीं। जैसे पहले मैंने टेलीग्राम वायर का जिक्र किया कि कोई रख नहीं सकता। अब टेलीग्राम वायर नाम की जैसी कोई विषय है बचा ही नहीं है, अनलॉफुल एक्टिविटी बची नहीं है। ऐसे ही एक शुगर कैन का विषय था कि शुगर कैन को हम असेंशियल कमोडिटी जैसा मानेंगे। अब असेंशियल कमोडिटी एक्ट आ गया, उसमें चीजें डिफाइन होगी, शुगर कैन का उसमें विषय ही नहीं रहा। तो ऐसे अननेसेसरी के एक्ट थे, लेकिन इस पे सोचा नहीं किसी ने। हम अगर यूपीए कालखंड की बात करें 2004 और 14 में साहब ऐसा एक्ट जिसकी प्रचलन में किसी आवश्यकता नहीं, वो समाप्त नहीं हुआ। और मोदी जी के आने के बाद 1562 ऐसे समाप्त हो जाएंगे। इसलिए नागरिकों को सुविधा देने का काम प्रधानमंत्री मोदी जी तेजी से कर रहे हैं। जैसे मेटल कॉर्पोरेशन है, अब मेटल को एक्वायर करना अपराध,
मेटल, कोई मेटल कॉर्पोरेशन का एक इसमें मैं लेकर आया हूं। तो अब इस तरह की बहुत सी चीजें हैं जिनका जिक्र अलग अलग सदस्यों ने किया है, लेकिन मैं फिर कहता हूं कि इसमें अलग अलग मिनिस्ट्री का काम होता है, कुछ एक्ट स्टेट के होते हैं, कहीं पर स्टेट्स की ओपिनियन भी ली जाती है, इन सब में टाइम लगता है। लेकिन ये भी एक काम था, मोदी जी से पहले इस पे तेजी से विचार नहीं हुआ, मोदी जी के आने के बाद लगा कि भाई ऐसा ये भी एक काम है, अननेसेसरी के एक्ट क्यों पड़े हुए हैं। इसलिए मैं जो कई बार कहता हूं कि जो पंच प्रण है, जो प्रधानमंत्री जी ने कहा है, लाल किले की प्राचीर से भारत को विकसित भारत बनाना, मानव केंद्रित, ईज ऑफ लिविंग, यहां भी एक विषय आता है। गुलामी का कोई भी अंश हो उससे मुक्ति मिलनी चाहिए। ये कानून जो गुलामी के पीरियड के बने हुए हैं उससे हमें मुक्ति मिल रही है, वो भी पंच प्रण के माध्यम से हमें उसमें जो है, जो प्रधानमंत्री जी के पंच प्रण का विषय है, उस दिशा में भी हम तेजी से बढ़ रहे हैं। एक सनसेट क्लॉज के बारे में जो पी विल्सन साहब कह के गए, मैं ये कह सकता हूं कि सनसेट क्लॉज इज अंडर कंसिडरेशन ऑफ द गवर्नमेंट एंड द सनसेट इज बीइंग कंसिडर्ड एंड कंसल्टेशन ऑफ द कंसर्न मिनिस्ट्री एंड डिपार्टमेंट। तो आगे उस पर क्या विषय आएगा हम आपको बता देंगे। फिर मैं कहना चाहता हूं कि ये मोदी सरकार है जो आगे बढ़ने में विश्वास रखती है, इसलिए हम ऐसे एक्ट जिनकी कोई आवश्यकता नहीं है, जो ठहरे पानी की तरह हो गए हैं, उन्हें रिपील करने का काम आज इस बिल के माध्यम से मान सदन के समक्ष मैं लेकर के आया हूं। मैंने पहले भी कहा था, अगर आगे बढ़ना है तो बहता पानी बन जाओ, अगर आगे बढ़ना है तो बहता पानी बन जाओ, ठहरा पानी थक जाता है वह तो अपनी काई से, काई उसके ऊपर ही होती है, लेकिन एकदम ठहर गया पानी तो वो काई से भी थक जाता है। तो ये ऐसे कुछ कानून थे जो खुद भी थक रहे थे, नागरिकों को भी थका रहे थे। कुछ विषय जुडिशरी से संबंधित भी आए, कुछ टिप्पणी आपने भी की, और कुछ जजों की अपॉइंटमेंट को लेकर के कि सभी सामाजिक।
माननीय मंत्री
जी,
we all are proud of our institutions. There are three main organs:
जी,
the legislature, the executive, the judiciary.
जी,
The executive has performed phenomenally. The world has recognized it. We noticed it during G20. We have seen infrastructural growth of unbelievable dimension. Elevation of poverty has taken place. So executive is performing very well. These are not political issues, they are above politics. Our judiciary has a robust infrastructure, known for its independence globally. Our judiciary recently has taken several innovative steps. Even I have directed our secretariat to get in touch with the Supreme Court Secretariat about translation. Our judiciary has attained milestones by making available judgments in the language people understand. Many things have happened. There will always be issue between organizations because we are in a dynamic world. Those issues have to be settled. Some issues may arise from this side, some issues may arise from executive, some issues may arise from judiciary. And therefore, this parliament, this august house, the upper house, is committed to giving highest respect to all the organs, because only in togetherness, in tandem, we can achieve success of our democracy to a higher level and take it to 2047 as a developed nation of the world. Therefore, the intent is that if there are difference of opinions, that is just a perception which can be smoothly ironed out. And I have no doubt with a minister like him who has seen the executive, he has operated legislature also by virtue of being district magistrate. You have dual powers. So he is eminently suited and belongs to a category of Dr. Ambedkar. So he is the right person, a right platform to smoothen out if there are any rough edges. But we take pride in all our institutions. It is this House that has done justice to one half of humanity by providing for reservation to women. It is this House that did away with the temporary provision of Article 370. Historic, epochal events have taken place. So it is from that perspective, the honorable member made some reflections. We have to see it in that perspective. Honorable Minister.
सर, आपके जो ऑब्जर्वेशन थे, आने वाले समय में जब कभी भी इस दिशा में हम आगे बढ़ेंगे कंसल्टेशन के प्रोसेस में, आपके जो अवेलेबल सुझाव हैं, उनको हम उचित प्लेटफॉर्म पर जरूर उठाएंगे, क्योंकि सामाजिक प्रतिनिधित्व सब वर्गों का जुडिशरी में होना चाहिए। ये आज के इस ऑब्जर्वेशन का मैं सार समझ पा रहा हूं। देखिए, जो भाषा का विषय आपने रखा, एक फंक्शन में राष्ट्रपति जी और चीफ जस्टिस ऑफ इंडिया और हम सब लोग थे, उस समय ये भाषा का विषय आया कि ऐसी भाषा में आपके जजमेंट होने चाहिए। आप भी तो जनता के लिए हो ना, सब हम जनता के, वी द पीपल ऑफ इंडिया करके कॉन्स्टिट्यूशन के सबसे पहला वर्ड वही लिखा हुआ है। तीनों अंगों के लिए भी वही सुझाव है कि हम लोगों के लिए काम करते हैं, नागरिकों के लिए काम करते हैं। तो सरल भाषा में होगा, सब लोग समझेंगे। तो मुझे लगता है जुडिशरी ने इसको बहुत अच्छे ढंग से लिया है और इस दिशा में तेजी से काम हुआ है। एक ई कोर्ट के लिए भी अच्छा काम हुआ है। अगर आपके सेक्रेटरी जनरल साहब, अगर उनके सेक्रेटरी जनरल, उनका भी पद नाम सेक्रेटरी जनरल
हो गया है,
हाँ, तो उसमें आप बात करेंगे तो मुझे लगता है कि काफी सुविधा रहेगी। दूसरा एक विषय और, आपने बाबा साहब डॉक्टर B.R. अम्बेडकर साहब का नाम लिया, तो मैं आपकी जानकारी में लाना चाह रहा हूं कि सुप्रीम कोर्ट के परिसर में बाबा साहब का चित्र नहीं था, मतलब प्रतिमा नहीं थी। तो वो अगर 14 अप्रैल या 6 दिसंबर का फंक्शन कहीं मनाते थे तो चित्र फोटो रख करके मनाते थे। अब पहली बार जब डॉक्टर B.R. अम्बेडकर ने, बाबा साहब ने 1923 में अपनी वकालत शुरू की थी, उनके वकालत के 100 साल पूरे होने पर वकालत की ड्रेस में सुप्रीम कोर्ट के मेन लॉन में उनकी प्रतिमा लग गई। ये भी बहुत बड़ा विषय सुप्रीम कोर्ट ने किया है। इसके लिए हम सुप्रीम कोर्ट को धन्यवाद भी दे सकते हैं आपके माध्यम से। मैं समझता हूं कि चर्चा काफी ठीक हो रही है। तो ये जो द रिपीलिंग एंड अमेंडमेंट बिल जिसके बारे में चर्चा हुई है, उसको पास करने का मैं अनुरोध करता हूं सर्वसम्मति से। थैंक यू।
The question is that the repealing and amending bill 2023 as passed by Lok Sabha be taken into consideration. Those in favor will please say aye. Those against will please say no. I think the ayes have it. The ayes have it. The motion is adopted. We shall now take up clause by clause consideration of the bill. Clauses 2 to 4, eastern part of the bill. Those in favor will please say aye. Those against will please say no. I think the ayes have it. The ayes have it. Clauses 2 to 4 are adopted. First schedule and second schedule and third schedule, eastern part of the bill. Those in favor will please say aye. Those against will please say no. I think the ayes have it. The ayes have it. The ayes have it. First schedule, second schedule and third schedule are adopted. Clause 1, the enacting formula and the title eastern part of the bill. Those in favor will please say aye. Those against will please say no. I think the ayes have it. The ayes have it. The ayes have it. Clause 1, the enacting formula and the title are adopted. Shri Arjun Ram Meghwal to move that the bill be passed.
Honorable Chairman, sir, I move that the bill as passed by Lok Sabha be passed.
Motion moved that the bill be passed. The question is that the bill be passed. Those in favor will please say aye. Those against will please say no. I think the ayes have it. The ayes have it. The ayes have it. The bill is passed. Honorable members, I had indicated to the House that I will come back to the House with respect to an update on the incident. The culprits have been apprehended. The matter is under investigation. and it will take its own course. Honorable members, I wish to seek sense of the House. We have special mentions. Some of the members have chosen not to be present in the House. बात कुछ भी होती है, पर कारण कुछ भी हो, इस कुर्सी पर बैठने वाले का दिल बहुत बड़ा होता है. जो नहीं है, उनके अधिकारों का ध्यान ज्यादा रखना पड़ता है. ये मैं उनके विवेक पर सोचता हूं कि उन्होंने अपना उत्तरदायित्व कितना निभाया, किस तरीके से निभाया. I think sense of the House is that we take it on the next day. Because reading a special mention is not ritualistic. Every member is benefited by listening to it. Every member gets enlightened thereof. This is an exercise too serious, and we must take it as such. Do I have leave of the House? So the special mentions will be taken up in due course. The House stands adjourned to meet at 11 a.m. on Thursday, the 14th December 2023.